Your landlord just walked into your apartment without telling you. Maybe it was to check something. Maybe they said they texted you. Maybe they just let themselves in while you were at work and left a note on the counter. Here's what most tenants do in that moment. They get angry. They fire off a message. They get into an argument, and they lose. Not because they're wrong, but because they don't know what they actually have. What I'm going to show you in the next 13 minutes is exactly what your landlord is and isn't legally allowed to do. And more importantly, what you can do about it if they've already crossed the line. Because depending on what happened, they may have just handed you real leverage. I'm a lawyer. I've worked through more landlord-tenant situations than I can count, from the tenant side and the landlord side. And what I've seen consistently is that the law gives tenants more protection than most people ever use, because most people don't know it exists. So let me show you how a lawyer actually thinks about your situation. When I look at a landlord entry situation, I'm asking 3 questions. And these questions determine everything. Question 1, what does your lease say? Because your lease is a contract. It may have terms about entry that go beyond what the law requires. Question 2, what does your state law say? Because state law overrides your lease. A landlord can't write a clause giving themselves unlimited access and make it enforceable. The law just doesn't allow it. And question 3, this is the one that matters most right now. What did your landlord actually do, and do you have it documented? Those 3 questions give you the map. Let's walk through each one. Here is the baseline rule in the United States, and it applies in nearly every single state. Your landlord must give you advance written notice before entering your unit. In most states, that's 24 hours minimum. In some states, California, for instance, 24 hours is written directly into the statute. In others, it's 48 hours. A handful of states don't specify a number, but courts have consistently held that reasonable notice means at least 24 hours in most circumstances. And the notice isn't just a courtesy, it's a legal requirement. A landlord who enters without proper notice is not just being rude. They are potentially committing a violation of your right to quiet enjoyment. I'll come back to that phrase, quiet enjoyment, in a moment, because it's more powerful than it sounds. Now, what are the exceptions? Because landlords will always bring up the exceptions. Genuine emergencies. A burst pipe flooding the unit. A gas leak. A fire. If there is an immediate risk to the property or to life, yes, in that case, a landlord can enter without notice. But the emergency has to be real and documentable. If a landlord says, I wanted to check the pipes, that's not an emergency. If a landlord says, I thought I smelled gas, when there was no gas leak, that's not an emergency either. Courts have seen every version of this argument, and they take a dim view of manufactured emergencies used to bypass the notice requirement. Here's the important phrase I want you to remember. Quiet enjoyment. It sounds like it means your apartment has to be quiet. It doesn't. Quiet enjoyment is a legal term that means you have the right to use your rental property free from unreasonable interference, including interference from your own landlord. In most states, the right to quiet enjoyment is implied in every residential lease. That means even if your lease doesn't mention it at all, or even if your lease actually tries to waive it, you likely still have it. It is that foundational. So what violates quiet enjoyment? Things like repeated unauthorized entries, showing up unannounced multiple times a month, sending repair workers without notice, calling you excessively. All these things, these are not just annoyances. They can form the basis of a legal claim. In some states, repeated violations of quiet enjoyment give you the right to terminate your lease without penalty. Let that sink in. If your landlord keeps entering without notice, they may actually be giving you the legal right to walk away from your lease. Now, I want to talk about something that doesn't get nearly enough attention. Landlord retaliation. Here's the scenario I see play out constantly. A tenant complains about a repair. Maybe something like a broken heater, a mold issue, a pest problem, something like that. They make the complaint in writing. But then, within a few weeks, something changes. The landlord maybe starts showing up more often. Or maybe the landlord suddenly wants to do an inspection. Or maybe they send a notice about something trivial. That pattern, complaint followed by increased landlord activity, is called retaliatory conduct, and in almost every state, it's illegal. Federal and state law prohibits landlords from retaliating against tenants who exercise their legal rights. Reporting code violations, requesting repairs, joining a tenants union, contacting a housing agency, these are all protected activities. And retaliation against them can expose a landlord to significant damages. In some states, even up to 3 times your actual damages, plus attorney's fees. The key here is documentation. Courts will always look for a timeline. Complaint, landlord behavior change. If you have that documented, timestamps, text messages, written notices, you have the beginning of a retaliation argument. Which brings me to what you should actually do right now. Here is your action stack. Do these in order. Priority 1 first. Step 1. Document what happened. Right now, today. Write a factual account. Date, time, what occurred, who was there, what was said. Send it to yourself via email so there's a timestamp you didn't create. If you have texts from your landlord about the entry, screenshot them immediately. Evidence degrades. Get it while it's fresh. Step 2. Pull your lease and read the entry clause. What does it say about notice? What does it say about permitted purposes? This tells you whether your landlord also violated a contract term on top of the legal violation, which matters for your options. Step 3. Look up your state's specific landlord-tenant statute. I've linked a resource in the description that goes state by state. Check the link, find your state, find the entry provision, write down the specific notice requirement and the remedy. You'll want the exact citation. Step 4. If this has happened more than once, send a written notice to your landlord. Not aggressive, but factual. On insert date, you entered the premises without the required insert hours notice required by insert state statute. Please be advised that future entries must comply with the notice requirement. That letter does two things. It creates a record, and it removes any "I didn't know" defense from your landlord. Step 5. If the behavior continues after that letter, you have real options. In most states, you can file a complaint with your local housing authority. You may be able to pursue a small claims action, and depending on your state, you may have the right to terminate your lease without penalty. I've also left a link in the description to tenant rights organizations by state if you need help navigating what comes next. Here's your action stack one more time. Step 1. Document what happened. Email it to yourself today. Step 2. Pull your lease and read the entry clause. Step 3. Look up your state's notice requirement. Step 4. Send a written notice to your landlord citing the relevant statute. And step 5. If the behavior continues, you may be able to commence a housing complaint, file legal action in small claims court, or perhaps even have the ability to terminate your lease. Remember, if you have questions about when your landlord is or isn't legally able to enter your apartment, refer back to this action stack and work through these steps in order. Before you go, I want to hear from you. Drop your situation in the comments. Not for legal advice, but I want to know what you're actually dealing with. What's your landlord doing? Or what did they do? I read the comments on every video, and the questions you raise directly shape what I cover next. If this video was useful, the subscribe button is right there. New video every Tuesday. No filler, no fluff, just the legal information you actually need. And if you're dealing with a workplace situation, maybe something your manager said that didn't feel right, or a performance review that came out of nowhere, I want you to watch the next video, because here's something most employees don't realize. Your employer's right to monitor you, discipline you, and yes, even fire you, has more limits than they're telling you. That's next Tuesday. See you there.